Good evening, everyone. Thank you for your patience, for those of you who've been waiting for a few minutes. My name is Patrick Kaiser, and I'm a Professor of Law at La Trobe University, and I'm also the head of the law school. And a long time ago, I watched a film called Reservoir Dogs, and there's a scene where the two robbers go back to the meeting point, to the hideout after the robbery. And one of the robbers says to another one, "Did you kill any people?" And the other guy says, the other robber says, "No, just cops." And that's how it sometimes feels being a lawyer, because often as a lawyer you have conversations with other lawyers about law stuff, and they have conversations with you about law stuff. But I want you to know that even though I'm a lawyer, I'm actually a nice person, and you don't need to hate me. Some of the people here tonight are lawyers, but if you're not a lawyer, you're amongst friends. We're here to talk about an issue that affects all of us, and that's social media. And I think social media and the law, very topical. Social media in particular, I've got an 11-year-old daughter. She's very keen on Instagram. She seems to spend a lot of time on Instagram. In fact, I hazard a guess that she spends 2 or 3 times as much time on Instagram as she does on her homework. But perhaps that resonates with some of you here. So I'm interested in what's going to happen tonight. I'm looking forward to seeing how it all unfolds. Let me just give you a quick rundown of the format of tonight's event so you can appreciate that you'll all get an opportunity to ask questions of our expert panellists as we go through tonight. I'm going to give you a very brief presentation of about 10 or 15 minutes, just talking to you about social media generally, and also taking the opportunity that I get from being the chair of tonight's event to talk about an issue that interests me, and that is social media and juries, which is an area where I've been doing some research in the last 18 months to 2 years. So I'll talk about something that interests me because I get to go first and because I'm going to do that. Then I'm going to introduce our panellists who are experts. In fact, I'll do that in a moment. I'll introduce our panellists, then I'm going to speak, then I'm going to invite each of our panellists to answer a particular question that I'll put to them that I think will interest you, and then we're going to throw it up to all of you to participate in the event, and we'll have a roving mic, and if you'd be good enough to raise your hand politely, then as chair I will select you to ask a question, and then if you can wait until you have the roving mic before you ask the question, that would be good, because tonight's event is being filmed so that we can produce content, because that's what we do at universities these days. So if you can wait until you get the roving mic, that'd be good. Now, as you can see, because we're all social media savvy, there's a Twitter handle behind me. If you'd like to live tweet and also take part in the conversation on Twitter, you can do that. So there's the hashtag information, LawMKW, easy to remember. Rolls off the tongue like a brick. You might want to write that down. Or Knowledge City, that's easier to remember. Hashtag Knowledge City. All right, or you can follow us at La Trobe, as we'd encourage you to do. Let me introduce tonight's eminent panel. Firstly, I'd like to, from my left, moving to the far left, my immediate left to the far left. Firstly, Hugh Stevens. Hugh Stevens he describes himself as a serial entrepreneur, and he runs a number of companies. Not yet. He's not running countries yet. In time. Okay. He runs a number of companies, primarily in the technology and social media space. He's the director of Dialogue Consulting, and they specialise in providing social and digital media strategy advice, risk and advisory services. Dialogue Consulting also operates multiple startups, including Schedugram, a tool for businesses to use Instagram and barometrics, a platform to allow large enterprises to monitor employee satisfaction metrics. Don't ask my staff what they think. Through these projects, Hugh has experience in identifying market needs and developing specialist products, along with the build, launch and marketing of the subsequent platforms. He's got a lot of experience across a wide range of sectors, regularly draws on his experience in IT, healthcare, statistics and the risk management sectors. He's worked for the state government, a number of healthcare institutions, multiple universities, including a number of other universities which I won't list at this point in time because they're not as good as ours. and private clients including AMP Financial, DDB, Lend-Lease and not-for-profits like the Red Cross. Would you please welcome Hugh Stevens tonight? Thank you. Next along is my wonderful colleague Mark Trabsky, and Mark's a lecturer at the La Trobe Law School. He writes on the intersections between legal theory, history and aesthetics. A common thread throughout Mark's scholarship and research is the relationship between law and technology. He's published a number of articles, presented at national and international conferences, and currently is researching online privacy in the era of Facebook. Please welcome Mark Trabsky. Thank you. Next to the left is Dr. Andre Abola. He's Chief Executive Officer of the Online Hate Prevention Institute. The Online Hate Prevention Institute is Australia's only charity dedicated to the problem of online hate, and its focus includes cyber racism, online religious vilification and other group-based forms of online hate, as well as cyberbullying of individuals. He's also the Asia and Pacific Region Coordinator and a distinguished visitor for the IEEE, which stands for the Institute for Electrical and Electronic Engineers, and he's a frequent guest lecturer at La Trobe. He's favoured me with some copies of recent research reports produced by his online institute, including recognised hate speech, anti-Semitism on Facebook, and also attacking the Anzacs on Facebook. He's also been doing some research on anti-Muslim hate, and I'm sorry to report that in his research he's learned that Australians are disproportionately represented in that particularly category of hatred in his research. So it'll be interesting hearing more about Andre's research tonight. Would you please join me in welcoming him to our panel tonight? And last but certainly not least is another one of my colleagues, David Loudon. He began his career as a cadet journalist in 1989. As a reporter for radio and then television, he covered police rounds, courts, industrial relations and general news before moving into sport in 1993. His master's thesis discussed how to apply ethics on the run in sports journalism by looking at the case of Channel 7's decision to publish information gained from the medical records of two AFL players. David's currently completing a doctorate on homosexuality in the AFL through La Trobe University Centre for Sport and Social Impact. He's the coordinator of the Bachelor of Journalism Sport degree. And just to give you an idea of the sort of experience that La Trobe students get, which of course students at other universities don't, is while David was freelancing for Foxtel during the Olympics recently, he was Skyping his Olympic reports back to his students, La Trobe students, of course. So please join me in welcoming David Loudon. I'm sure you'll agree with me, we have an outstanding panel tonight. I'm sorry that there are no women on the panel. We only really discovered that tonight. It's an accident and it's an oversight, and I apologise for that. But in spite of the fact that they're men, I'm sure you'll be nice to them when you get your opportunity to ask them questions. So I'm just going to quickly talk about something that interests me because it's the chair's prerogative, and that's social media and juries, which is an area I've been researching for a number of years, and it gives me an opportunity to incidentally introduce some of the larger concepts that we're considering tonight. I might just step to one side. Hopefully the camera can still see me and I can see the slides as well. Oh, I can also see them at the back of the room. Wonderful. That's fantastic. Well, social media has been defined as a set of internet-based tools used for sharing and discussing information. Okay, well that seems like a fairly obvious thing. It includes user-generated information, opinion and other content shared and discussed over open digital networks. And that's the definition that ACMA has given us to use. People who use social media regard it as a participatory culture where they pool resources and skills. And they see social media as a tool for gathering information, sharing stories and discussing concerns. It's where contemporary discourse is happening on social media. Now, I wouldn't be a professor if I didn't take you through some statistics. Social media usage in Australia is ubiquitous and prolific. Australians are prolific social media users. These are some statistics from June 2014, and I'm sure that they're hyperinflated from these points already. There are 13,200,000 Australians on Facebook. Now, I'm not sure how many of you have got multiple identities on Facebook, but that's a lot of people. That's more than half of Australia's population. There's 3,700,000 people on LinkedIn. There's almost 3 million people on Blogspot, which is something I'm not familiar with myself, I've got to admit. 2,500,000 of us are using Twitter, and more than 1 million are using Instagram. A recent international study, showed that Australians share everything on social media. That we're the 14th highest in terms of social media sharing, which I have to admit I was a little bit surprised about. I thought we'd be higher, but still a lot of sharing going on social media. And Australians have been found to spend an average of 7 hours and 17 minutes a month on social media networks, which is the most in the developed world. I think that must be a misprint. They obviously weren't looking at my daughter's Instagram usage when they were compiling those statistics, or perhaps because I don't think she's an outlier if the social media habits of the young people I know are any indication. All right, okay, so there's some general statistics about the breadth and prevalence of social media. And now I just want to drill down very quickly into something that interests me. And if you've got some questions you want to ask me about this, during the group Q&A session, you'll get an opportunity to ask me questions about this. Early last year, in March of last year, I went to a conference and met with 62 judges, magistrates and stakeholders in various courts in Australia. And I engaged in some focus group research with the judges to try and find out from them what the courts think about social media. Are courts anxious about social media? Do they see it as a place of opportunity, or do they see it as a threat? The courts see social media as a threat. I think it's fair to say, generally speaking. There are certainly some courts and some judges in some courts who have a very proactive and open approach to social media. And I'm not just saying that because I'm standing in Melbourne, but the Chief Justice of Victoria and the Supreme Court of Victoria are definitely leaders around the country in this space, and they are acknowledged to be so. So Chief Justice Warren and Anne Stanford from the Supreme Court of Victoria doing wonderful work, leading the way in the courts in this area. But a lot of judges were very anxious about the issue of courts and social media, and they identified by a country mile the most important issue as being juror misuse of social media and digital media leading to aborted trials. So the judges are very anxious about this issue, very, very anxious indeed. And it shouldn't surprise us because we are now starting to get regular reports of trials being aborted because a juror has gone on social media or has used digital media to conduct their own research, to be detective jurors, as Jackie Horan from the University of Melbourne has described them. So this is a big issue, and I'll come back to it in a minute. The next two big issues were concerns about breaches of suppression orders and sub judice issues when information goes viral, and also the increased risk of cyber stalking or opportunities for invasion of privacy, which of course is an expertise of my colleague Mark Trabsky, and he'll probably be talking about that in response to some of your questions tonight. So those are the big issues. Now, there were lots of other issues. There were actually over 20 issues that they identified, but these were the top three. Issues. Okay, now the big issues with juries and social media, again, that's the most important issues for the judges, is that the new technologies are ubiquitous. You know, phones, tablets, so much technology, so many different social media platforms. So much so that the Attorney General of the United Kingdom, Dominic Grieve, coined the phrase trial by Google. And he's concerned, like many other policy leaders, that we're moving to an environment where people are being tried. We're familiar with the concept of trial by media, but now trial by Google. So people are getting onto Google and conducting research about people who are accused of crimes, risking their right to a fair trial. And of course, that's a very significant issue indeed. Joanne Trail, about 3 years ago, in 2011, Joanne Trail was a juror who was participating in a jury in a drugs case in the United Kingdom, and she friended the accused on Facebook. Now, I'm sure you'd think that's a crazy idea, and of course she was warned against that sort of thing by the judge, but did it anyway. She was charged and convicted of contempt and given a 6-month imprisonment sentence. But penalties don't seem to be working. Penalties exist in all common law jurisdictions to control social media use, digital media use, research by jurors outside the evidence that's adduced in the course of a trial, but it doesn't seem to be stopping people from doing these things. So we have to re-examine the menu of options that we've got to look at ways we can do these things better. Cheryl Thomas of the United Kingdom, in her research in 2013, found that significant percentages of people were using social media, and on significant percentages of jurors. Now, you'd have to expect there'd be underreporting in these sorts of surveys, because people don't always admit that they've just done something wrong. So we're allowing for the underreporting, we're looking at significant percentages. And of course, sometimes people do silly things on Facebook, sometimes people do particularly silly things, like the juror who conducted a poll on Facebook to help her decide whether the accused should be found guilty. Not a good idea, not very clever. So how do we handle this? And I'm moving down to my last two slides, and then I'm going to open it up to the panel with some questions. Do we penalise independent jury research, which is what we've traditionally done, and certainly in the last few years there's been a legislation enacted in most states and territories reinforcing the penalty provisions here. Is that an appropriate response? Should we prohibit social media use outright? I mean, certainly we can take phones away from people, but is that going to stop them from doing things at home? Do we need to delay the start of the trial, which is a common technique used when there's been prejudicial pre-trial publicity? Should we introduce jury hotlines to get people to dob in other jurors? Should we adopt a mixed jury approach that they do in some continental jurisdictions where they have professional jurors mixed in with lay jurors? Or should we have judges mixed in with the jury? Should we engage in internet screening? So you can't participate in a jury unless your IP address is provided to the court, and then they can find out what you've been up to. Well, you know, what do you do then? You use your son or your daughter or your spouse's IP, or you go to an internet cafe. Do they still exist? I'm not sure. We can take the phones away from people. Maybe we should go back to the approach that they took in the 14th or 15th century, where they'd sequester people. So they'd take the jury and they'd put them on the back of an oxen cart, and they wouldn't feed them or give them water until they decided, okay, now it sounds fanciful, but maybe what we're going to need to do is actually put people up in hotels and keep them away from outside influences so they can make the decisions on the basis of the evidence. You know, we need to consider all possibilities here. There's a lot of research going on at the moment on don't research jury instructions that are issued by judges. Jury training is something that's also currently being studied. And as you might expect, as a professor, the very last message I'm going to give you is more research is needed. More research is needed, which of course means that more stakeholders should provide more funding for more researchers to conduct this research. But seriously, more research is needed about what we can do to assist jurors so that they feel that they don't have to go and use social media, or that they ought not use social media during trials, and also to make them more better consumers of information. Again, you'll have an opportunity to ask me questions about my general introductory paper in a few minutes, but what I'd like to do now is I'd like to get the ball rolling, shift from my talk to a panel discussion with the panel. I'm going to pitch a question to each of our panellists. They're going to have 2 or 3 minutes to answer, and I'll be keeping them strictly to time, and then we can open it up to all of you. So that'll be the format. Now, you'll remember we have Hugh Stevens, the social media entrepreneur, Mark Trabsky, the lecturer in law, Andre Ebola, who's the CEO of the Online Hate Prevention Institute, and David Loudon, who's our sports media journalist, who's Skyping his students from Olympic events, which sounds very exotic, a lot more exotic than the sorts of things I get to do. So that's who we have here. I might pitch my first question to Mark, if that's all right, Mark. And you've got 3 minutes to answer a question that could take 3 hours. But do you feel that the law is adapting at all to the changes wrought by social media? Mark.
Thanks, Patrick. I think the relationship between law and technology is quite complex, and I'm not sure if I'm going to be able to answer this question in 3 minutes, but I'll give it a shot. In my research, what I found constantly is that law is playing catch up to technology. You have the emergence of a new technology, then you have a scramble to regulate that technology, and then finally when law is able to regulate that technology, you have a new technology. Now that encapsulates the current crisis of online privacy. I think it also, if I put another hat on, it encapsulates the current crisis involving digital piracy when it comes to downloading, streaming illegally. But this is what sometimes we forget. We forget that things have histories and that this crisis is not new. The technology is new, but the crisis isn't new. Now we could go back to talk about the invention of the printing press. However, I'm going to leave that for a moment. And go back to radio. When radio was invented, its magical properties had a huge effect on the population. Everyone was perplexed by it, people were excited by it. People who were not happy about it were owners of newspapers. And in fact, there's a case from the 1920s, which went right up to the High Court, involving the Victorian Racing Club in New South Wales. So it was called Victorian Racing Club, but it was based in Sydney. And what was happening there was people who usually go to the races, they weren't coming anymore. And the reason they weren't coming anymore is because they were listening to the races on radio. And there was a next door property, and in that property, someone erected a kind of viewing station or platform, and this local radio personality was there ringing up the radio station to report what was going on in the races. And the race club owners didn't like this because, well, people weren't paying to get into the race clubs, but also people weren't gambling. And what they tried to sue was, they were trying to sue this radio company for breaching the privacy of the race club. So they're trying to say, you're breaching our privacy by peering over into our race club. And the High Court, in short, said to the race club owners, sorry, we're going to deny your claim. If you want to fix it, you have to build a higher fence. And I think that analogy encapsulates the chase between law and technology. So whenever people come and say, this technology is out of control, we need to regulate it, in a lot of ways, judges are saying you've got to build a higher fence, or you've got to wait for Parliament to create legislation to regulate that technology. So from radio, we go through TV, we go to the VCR wars, and then we come, I'm skipping a few things, we come to the internet. Right now, we do have what people are calling a crisis online. And I think this crisis can also be described in a difference between our expectations of privacy on the internet and what the law will actually do to prevent the unauthorized disclosure. And I use the analogy, another one, I'm going to use a lot of these, of the faulty door. I think the internet is kind of like a faulty door. It creates the idea that when you enter the internet, you're in a private room. But however much you close that door, it's faulty, it's unhinged, anyone can get through. We see this recently with the hacks of iCloud and celebrities. They thought their photos were safe. A lot of people in this room, I'm sure, are using an Apple product and they do back up their data online. We all voluntarily sign, well, we don't sign anything, but we say accept and say, yes, we trust Apple, it's fine. But they got hacked, which suggests that it's not fine. And I mean, I'm not going to tell what I suggest because I'm going to leave this open for other conversations. But what I'm trying to say here is the crisis isn't new, but the technologies are new. And I think with each technology, there's more and more problems. Radio, back in the 1920s, 1930s, not a lot of people could afford to buy it. Some people could make it themselves, but not a lot of people could afford to buy it. And sometimes you would have one entire community listening around to the radio. With the internet, as we saw there, 13 million Australians are on Facebook. Have all those 13 million Australians read the terms and conditions and the privacy policy? Do they know what Facebook can do with your data? And do they trust Facebook? Do they trust them to protect their private photographs, their personal information?
Well, that's an excellent start, Mark. Perhaps next I might ask Hugh, because you're sitting right next to me, Hugh. Just reflecting on what Mark has told us about the challenges that the law has faced playing catch-up to technology. What are the challenges you see facing businesses, the risks for businesses working out their response to social media?
Yeah, it's I mean, it is a really difficult issue, and we talk about how challenging it is for individuals to come to terms with perhaps, how they should be approaching these technologies and what implications it may have for them down the track. But businesses and organisations, and you can include government departments and obviously educational bodies like this that may not identify as a business. Businesses don't really, they're still grappling with the same issue, and I think particularly in that sort of very executive level of corporate governance, it really is the question of what is this black box and what's it going to look like and what does it mean for us? And really, I think the risks that they face is that they face some very obvious risks, and the capacity for particularly reputational related issues, and whether that's defamation or or just generally like a PR disaster, is very, very real. But some of the issues that we do see are questions like, it's common in recruiting now to do a Google search about a prospective employee. Now, is that really legal? Is that ethical? Is there consent? Should there be explicit consent from that prospective employee to do that search? And certainly, we know in the States there have been examples where businesses, and particularly recruitment firms, have actually created false personas to then friend the prospective employee to actually see stuff behind that wall, to actually really try and get into that space. Now, is that something that is right? Is it wrong? And I think it's really a bit of a difficult question, both for the business itself to make, obviously, because there is that element of what is the actual corporate ethics and what are the requirements of this role. But in addition, do we really have consent for that? And would it be okay if that Facebook page was public? Would that be all right? Or what if it was something where it wasn't necessarily public, but you also had to have an account? So, for example, on LinkedIn, you can see a lot more information about most users if you also have a LinkedIn account. It's one of the ways they encourage you to sign up for it. And so, beyond just simply this question of do users really know what they're getting themselves into, do businesses? And they're obviously as well signing the same terms and conditions. They're signing the same privacy policy that users are signing when they're using it for their own interests, usually obviously for promotional purposes. And do they necessarily go through that whole process? And do they have, I guess, processes and practices in place to ensure that as they are, particularly I think some of the more, the more cutting edge, for want of a better term, some of the more cutting edge organisations, as they're joining every new platform as it appears, do they really see, what's the potential implication of that? Are we actually, discharging our common our common requirements of, even in some organisations, and having worked for some time in the mental health space, how do we discharge our duty of care, requirements? And I think often those are issues that they grapple with because there is no real legal precedent to say this is how far duty of care extends in an online space. And I think we can all argue sort of logically that duty of care perhaps extends further if you were Lifeline compared to if you were Coles, but where does that line really get drawn? And I think that's some of the really challenging issues that we're starting to see.
That's excellent. I might now introduce Andre into the conversation. Mark was talking about the sorts of that Victoria Park racing case where the High Court said just build a higher fence. And Hugh's just been reflecting on that fence and basically reflecting on how corporations, businesses, universities, governments are trying to work out how high the fence should be, whether there should be holes in the fence and that sort of thing. And then, of course, the work you're doing with your Online Hate Prevention Institute is actually finding out what's going on behind the fence. A lot of the research that you've done, you've done a lot of research on threatening online abuse, particularly aimed against religious folk and women, and even Anzacs. I was interested in learning tonight. Are online hate campaigns on the increase, or and what should we be doing about this sort of thing?
Okay. The biggest problem we've got right now is that I can't answer that question. I can tell you that from our perception, we're seeing a lot more of it, but I would like to be able to tell you that it's up 20% compared to last month as a result of, let's say, ISIS and the things in the media at the moment. And that's sort of the impression we've got. But all I can give you is samples, and that's not statistics. The data does exist. It's on a couple of servers at Facebook's headquarters, at YouTube's headquarters, but it's not available to, never mind the public, it's not available to researchers, it's not available to governments, it's not available to policy experts. The reason for that is because it's not in the company's interests to make this data public. Okay, this data shows that the scale of the problem is so much more than we imagine. If we knew how bad it was, we would be pushing much harder to get it fixed. And we see this even when we get NGOs and groups that deal with this problem together. We find that the technology companies have an escalation scale of how they deal with particular types of concerns. And we compare notes, and we know their playbook better than they know their playbook some of the time. And we can say, well, you've got to this level, this is what's going to happen to you next. What they're trying to do is retard any progress when it comes to the law in particular, because that is a liability to them. When governments do catch up and there are more penalties put on them, that's going to cut into their profits. At the moment, the more hate speech there is in social media, the more trolling, the more bullying there is, the more content there is. It is all just content. The more content there is, the more eyeballs there are, the eyeballs there are seeing it, and that means the more advertising revenue there is. And that's the model we're working with right now. So what we're talking about is taking something that's generating revenue and not only getting rid of it to remove that revenue, we're now saying that they need to start investing money into tackling this problem. So we're turning a stream of profit into a stream of costs. And that's the problem we've got. That's not in the company's interests. So whose interest is it? I would say it's in the public interest, and governments do have a role, and it's up to governments to represent that public interest and to force change. There was a time when companies, manufacturing companies, could produce as much pollution as they liked. Okay? That was just part of how they did their business. And local communities suffered, and it was due to the law that companies had to stop doing that. First, there were judgments, and they were found liable. And then we have governments actually passing legislation saying there are minimum standards, we create an environmental protection agency, and we make liability for the companies. Social media is currently still new enough that it's operating often as monopolies with the profit coming in and no liability for the damage that's being caused. I'd also like to take Hugh's example and go one step further. Firstly, creating a fake profile to investigate someone is a breach of the terms of service of the company. Let's fix that problem. Let's say LinkedIn or Facebook offers companies, we will give you all the data we hold on this person for a small fee. Let's say $10 per candidate. Great business for the companies, right? It's data that you've agreed to give them that they can sell. They do it anyway to advertisers. What stops them selling it directly to recruitment people, putting it in a much nicer form? This is the CV you've created. This is the CV Facebook, Google, YouTube have created about you. Okay? I think we get into a much more problematic space there, particularly when we're talking about something like Google and search engines. The results do get manipulated. Never mind what you want to be out there, or never mind what happens to be out there. What happens when you're in a small space, let's say you're a legal expert, and there's only 10 experts in your field? What happens if one of those 10 experts went and employed someone to go and do search engine optimization against you to rubbish your reputation, not just to increase their own, and suddenly you've got these profiles saying, no, you use this guy, you're going to lose. Yeah. Okay, so there's all sorts of ethical issues here, and some of this comes back to professional ethics for the people that build the technology, and there's not nearly enough emphasis for the people that develop the tools. There's this concept that technology is neutral. Technology can be neutral, but if you develop technology and make a capacity available and then don't manage the risk that that capacity creates, that's not a neutral position. Okay, that's developing a mechanical machine with no safety measures in place. We have liability for businesses that do that. Social media should be no different.
Yeah. I mean, personally, I'm quite anxious about what is out there in social media, because if I ever Google myself, all these photos of this really old guy come up, and that makes. Okay, final question is to just kick things off is for David. When we were doing our research on juries and social media, one of the issues that came up for us was the judges and the magistrates were telling us that they saw a difference between the quality of reportage on social media and the quality of reportage conducted by legacy media. So there was this belief, at least amongst a number of judges, that you're going to get better reportage if it's in print than from some of the social media platforms. And it's made me wonder, what has social media done to journalism, and what is how have journalists had to react to social media as it's become ubiquitous?
It's a very good question. Well, just on that specific point about the court, I was astonished that courts were allowing people to have their mobile phones in court, and clearly people can be surreptitious about it and have it down low. But when I was court reporter many years ago, there was it was absolutely banned to have any kind of electronic equipment. You could have your pencil and your notepad, and that was it. And I can't see why we don't stick to that. I think it's a really serious issue, because if you've got 140 characters and you want to get a number of hits, as you were talking about, maybe you're trying to get your media outlets' Twitter profile getting more hits to be the person that you follow so that they read more papers. And I think there's a motivation there to perhaps be sensationalist and not. You've got more time when you report as well. I mean, court reporting in itself used to be rushed, because you'd sit all day and then have to try and bash it out. But at least you had maybe a couple of hours. And even with radio reporting on courts, there was maybe the next bulletin's coming up. So there'd always be a window where you'd think, look, this is too rushed to get this out properly. And we'd all agree amongst ourselves, look, no one's filing? Right, good. Let's just get this down right. Because there was an understanding, I think, that you've got to get it right. Don't be first, be right, and then be first if you can. But there's a really interesting theme running through, which is not really a research area for me yet, but an area of interest more than anything, about ethics. And I'll, to take Mark's example of the racing club and the wall, I think we're getting to a point maybe in society where we need to more actively teach good decision making. I've got a couple of daughters in their early 20s, and I consider them to be intelligent, good people. But about early teens, I started saying, look, it's all about making good decisions. And I think the common theme here is that a lot of people have got this technology at their fingertips. There's no in between anymore, and people don't make very good decisions. So turning to sort of journalism, there's been a celebration of the fact, and in some quarters quite rightly, that the middleman's been cut out, the journalist. That there's now direct access between the primary source and the consumer. The downside of that is that the journalist, whether the reputation that follows them is a generalisation or not, is a trained specialist communicator, and trained to, at least in an ideal world, they're trained to pursue the truth. So they're actually, now I'm not sitting here and saying that always happens, but the role of journalism, if you put aside commercial pressures or people who are on the spectrum of doing the wrong thing or whatever, but if you actually focus on what journalists do, what they're supposed to do is report the truth, pure and simple. That can be Watergate, but that can also be something as simple as helping you make decision tomorrow about an event that's happening, the weather, whatever. You want to know the truth of the matter. So to Mark's example with the wall, at the time, we know about this now because it was said in court, but the reportage at the time, we haven't got time to wait for that case to come to court. We have to report that today. So the racing industry would be saying, this is not fair. We've got the races and we've got all these people and their jobs are at risk. And, the man on the tower would be saying, well, I'm just providing a free service for radio's invented now. We can't hold back radio. So what's the truth of that? What is the truth of that story? Because lazy reporting is just to go and get the racing club and publish what they say, and then go and get the man in the tower and publish what they say. But journalism's much more than just reporting evenly both sides. It's about pursuing the truth. Yeah,
so social media hasn't affected the professionalism we expect of good quality journalists.
Well, it hasn't affected it, but to the journalist, I hope. But you've now got a whole lot of competitors.
Yeah.
The common person who has access to publishing themselves for the first time.
Yeah.
So the printing press, was still was still the mechanism for trained people to publish, but now we have everyone able to publish, and what we don't have is people making good decisions.
That's an excellent place to start. All right, well, this is our opportunity, folks. There are many of you and few of us, and as you can see from the responses of the panellists so far, we've got some fabulous expertise in front of us. And so now is our opportunity to open the floor to people who would like to ask questions, and please, we would prefer to get questions and comments, unless you're going to compliment me on my tie. Can I ask you to raise your hand and we'll bring the roving mic to you. Can you keep your question brief? And can I ask the panellists to keep their responses brief? You can identify a particular person that you'd like to ask a question, or you can just send it to the panel. Again, let's see, it's 7:10. We've probably got about 20 minutes, half an hour for this. So there's a lot of you, and a lot of you will have something to ask. So we'll need to be crisp, and I'm going to be brutal in closing people down. If I can ask you to, you've got the roving mic, sir, so you can start tonight.
Thank you. This is a question perhaps for Patrick or Mark. Just picking up your comments about juries and the attitude or the current feeling from judges and magistrates about how this technology should be managed. Do you think that there is a real risk that injunctions are potentially not so much useless, but very, very difficult to enforce? And I'm thinking now of the recent Supreme Court injunction against the publication of material to do with the Malaysian, the Reserve Bank executives who were charged with fraud. There was some material that was leaked out of the court. There were no publications in Victoria that published that material, but it was published overseas. And on the Facebook page of The Age that very day, a reader linked to a Malaysian publication which had the full details of the story. So effectively, anyone in Victoria was reading that material without having to look further than a local Facebook page. What do you see as being the implications for both the publisher's responsibility and the courts and judges' attitude towards how they enforce and police and, in fact, hand down injunctions?
Well, look, just picking up on Mark's point first, old wine into new bottles. We are behind the technology. That's obvious, and so your question amply demonstrates the example. I commented about that decision of the Supreme Court in the WikiLeaks injunction case for The Age, and I still believe that what I said in that comment was correct, which was that obviously the Supreme Court, if it's presented with submissions from counsel asking for suppression and they're persuaded that the information should be suppressed, then they should make those orders accordingly. And even though I know the courts and the judges are mindful of the limitations of suppression orders, it's really the only thing that they've got, really. So yes, the technology is way ahead of the capacity of suppression orders to control it, and that is a significant problem. But I know that the judges and the courts are aware of that and are thinking about those sorts of issues. At this stage, it may be an opportunity for the legislature to step back in if they do think that this sort of information needs to be suppressed. Or maybe what we need to do now is have a good hard look at whether this sort of information can be suppressed at all. It's a very, very, very difficult area for the courts. They're acting according to law. They're making their decisions on the basis of the submissions in front of them. And if you make a good case that information should be suppressed, that's exactly what they're going to do. Unfortunately, as you pointed out in your example, the technology is way ahead of them. It's a very difficult issue. Anybody else like to add something briefly? Yeah.
Just wanted to add that if it's on the Age's Facebook page, what liability should the Age have in terms of their moderation for a user-posted comment? If we agree they should have some liability and there should be some moderation, they should be removing it because they're aware of the fact that there is a suppression order, how long should they have to remove it? Okay, it's not reasonable to expect that they have someone there in real time monitoring every comment that comes up. But then how long do we give them?
Yeah, that's obviously a really significant point. There was another person over there. Yes, thank you very much.
Hi, my question's for Dave. I just wanted to ask around online journalism. Do you feel that with the, obviously there've been a lot of job cuts around sub-editors, etc. Do you feel that the quality of online journalism could perhaps be that of print journalism if they did put more of an emphasis in quality and making sure that there's better editing before it does go online, particularly with that whole trying to get it first, not right? I really like that comment as well. Thanks.
Well, it's clearly possible and desirable. I worked for a short time at I won't besmirch the company because it's not the story doesn't really relate to the name of the company, but a large organisation that its main reason for being is online journalism. And I was astonished when I joined that they had one person in Melbourne controlling the whole site, and that basically their job was just to trawl other sites and rewrite stuff. And I thought, this is not really journalism, is it? This is kind of, reappropriating and aggregating, but it's not journalism. You don't need me to tell you we're stuck in this model. We all know that the cover price ads for eyeballs model is just about dead. Problem is, and this is why I'm passionate, you can't research everything at once, so somebody else can hopefully pick this up. But this is why I think people need to be taught, even in schools, about good decisions, because it's second nature, particularly for people who are brought up with getting stuff for free, to expect it for free. And so there's no yet foreseeable way to charge for good quality journalism. And I say to my students all the time, especially I think you can get a student deal for about $50 a year for both of the papers around that. And I can't think of many products where you get so much information and so much benefit for such a small price, but people don't value it. And where the problem that we've got is that online journalism has become, driven by clickbait, as they say. It's all about now breasts and beer, and not proper journalism.
Can I just follow it up by asking if you think that if there was perhaps a better quality content online?
The chicken and the egg. I know where you're going. More people would subscribe if it was better.
I feel people want it now for free. But of course, if they can get it free and now, why would you do that?
I think newspapers made they clearly did. They made a critical error in offering. They saw the internet as a way of selling more hard copy newspapers, as an arrowhead to actually getting you interested in the article. But the Age is pretty much at the point now where they'll break the story online, and it wasn't so long ago that they would hold stories for the print and then put them online, and they're now pretty much it won't be long and the Age won't exist as a printed edition Monday to Friday. I don't know how long, but I'll be very surprised if it's here in 5 years, and that'll be a great shame. It's actually, even what we're doing today, I go to the Wheeler Centre a lot, and we're all sitting in a room talking about ideas and thoughts and things, and that's a very different experience than looking at a small screen and tweeting back and forth or whatever. So we, as a society, we have to come to grips with the good that social media does, but use it as a tool appropriately. And still, fight for, I think, some tactile things like books and newspapers.
Okay, where's our roving mic now? Yep, thanks very much. All our questions are coming from the back.
This kind of relates back to that first question about suppression orders. There's an increasing number of suppression orders being issued in Victoria, and one particular case that I think is particularly interesting when it comes to suppression orders is that surrounding Adrian Bailey. And there's a suppression order currently in place to suppress any details of any of his previous crimes because he's going on trial again next year. And I was just wondering how you think a suppression order can work in that instance when there's been so much information on social media, there's been so much information in print and online news services about Adrian Bailey and his previous crimes. Do you think the suppression order is appropriate in that case in order to allow a fair trial for Adrian Bailey?
I couldn't possibly comment because it's been suppressed.
That's not true.
No, look, obviously your question illustrates and again, as our first questioner his question illustrated that suppression orders aren't a perfect means of suppressing information. They were designed in the 19th century for the printed media when, after the morning paper had come out, you could suppress information before the afternoon paper came out. And I know because, that actually wasn't that long ago, even though it was designed in the 19th century. When I was 10, I used to have a paper route in Coogee in New South Wales, and I used to push a barrow up the hills there, and I'd sell, in those days, I'd sell the Mirror or the Sun in the afternoon. The Telegraph came out in the morning. The Mirror or the Sun, I remember when they were 10 cents, and I used to blow my whistle and sell the newspapers, and that's how people got the news. And I'm not that old, but that's what it was like, less than 40 years ago. And so suppression orders had something that they could work on. But the problem now is, as we know, there's a new language for what we're dealing with now. Information goes viral, and there's a reason why we use that expression. Because for many, it's regarded as a pathological dimension of social media, that the information becomes pathological, it goes viral, we can't control it anymore. And that's a significant problem for the courts. But I think it's really important that we don't just focus on the courts and suppression orders, because the courts are only one lawmaking body. There's also legislatures, and parliaments have got some responsibility in this area as well to set the right sort of balance in this area. So, for example, the Australian Law Reform Commission recently produced a very significant report on online privacy that Mark's been looking at in his research recently. And now the government has got an opportunity to legislate, if they want to settle a new balance in that area. Of course, as Andre demonstrated in his answer to the first panel question, there are very significant issues around whether the online platforms, the social media platforms, are actually going to want that sort of regulation, and there are some very significant ethics issues that Hugh also identified. But getting back to your specific question on the suppression orders about that particular person, I'm sure the courts had a good reason for saying that there should be a suppressed reportage about the identity of that person. I acknowledge that many people in Victoria, the overwhelming majority of adults in Victoria would probably know the name of that person that you referred to. And it does seem odd it may seem odd that we cannot speak about him generally or report details about him. But of course, there's the right to a fair trial. And a judge has decided that the right to a fair trial in that context requires some suppression of that information. And we do have the appeal system in Australia. So if we're unhappy with the suppression orders that are issued by trial judges or courts of appeal, we can appeal all the way to the High Court.
But I mean, the other side, and sort of giving the other side of the question, I think that we also need to think about is, does everyone here know the Streisand effect? So it sort of is a story of Barbara Streisand, who wanted to keep the nature of her giant mansion on a cliff totally secret. And so she actually managed to get an injunction to stop someone from publishing photos. Now, of course, the effect of trying to make something as secretive as possible is that all of a sudden it goes everywhere. And so it's now coined as the term, the Streisand effect, very good Wikipedia article on it. That is, Wikipedia can be a good source. It tells a good story. The story may not always be correct, but do we have this question? And certainly when you say that all adults probably know exactly the story that we're talking about, is part of that because of the fact that there is a suppression order there.
Andre.
Two thoughts on that. The context I normally hear about the Streisand effect on is someone is being bullied to the point where people are trying to push them towards suicide, and the victim in this case, is told, don't do anything about it because you'll just make it worse. Just live with it. I'm sorry, we've got someone that we work with who's been attacked in this way for almost going on 6 years now. They've totally destroyed this person's reputation. The person is a cartoonist. They were publishing articles in cartoons in newspapers and things. And one of the online forums started turning their cartoons into Nazi propaganda, neo-Nazi propaganda. And they leave their person's signature on them. You search for this guy's name now, and all you get is Nazi content. Do you think this guy's able to get commissions anymore? And when he tries to do anything about it, he gets told, the Streisand effect. You'll just make it worse. Leave it alone. After 5 years, 5 years plus, leaving it alone is not the solution. On the suppression itself at a technical level, I just don't see why it can't work. The question of whether there should be a suppression order or not is one for the courts. But why can't it be effective? If you give the person's name and maybe some other details to Google, and there is a legal mandate on Google to say that searches on this from within Australia and only within Australia give nothing, or give a thing saying there is an active suppression order, that's easily doable. You do the same thing on Facebook and you can't search for it. You've still got the problem of things going viral, but viral means that there is liking and sharing. That's what viral means. The platform can do the same search and say, is there liking and sharing of this item? Are we serving it to someone in a country where it's suppressed? They already don't show you everything your friends share, not unless the friends pay them money. So they can control whether you see it or not. All they have to do is say, you're in a jurisdiction where searches on this name are suppressed, therefore I'm not going to serve it to this particular friend. I'll serve it to someone in a different country. It's doable, technically.
But you yourself said that the reason why these companies won't do it is because it's going to eat into their revenues. And I think that there's one thing that we're misled about. Facebook is not free. We think it's free, but it's not free. Usually when you buy something, you get a product. With Facebook, you are the product. That is what you have to sacrifice in order to participate in this.
Only if government allows that. If government mandated that if they don't do this, there will be penalties on the company and it's not free for the company to do this, it would change.
But is there really political courage in this country in order to...
Say that you don't have political courage. You've got corporates that are running the politicians. So no matter, we can sit there, we can jump up to a blue in the face, but you haven't got the political courage.
And
just hold on a second, because you don't have the roving mic. So we'll get you to roving mic. But first I might give David an opportunity to chime in there, and then I'll give you an opportunity to ask your question.
It's just a small comment about supporting suppression orders, because journalists take them very seriously, as they should. And I know in sport, sport's a very popular part of Australian culture, as you're no doubt aware. And there is all the time discussion about who's on 3 strikes in the AFL, who's on 2 strikes. And these names go around the fan base. Oh, such and such, Joe Blow's definitely on. I heard it from, my hairdresser told me, and he's got a friend and because there is no, and I actually think journalists should be made, after a degree, to sit an exam and should be given a qualification like the law, like you get the skills, but then you actually be accredited. But that's a whole other story. But we need to separate professional information that's on the record and just social media scuttlebutt. And so the idea that just because it's around everywhere that we should give up and that suppression orders don't work, I would feel is waving the white flag. I think, I'm not sure how many people in the room now could name the club, and I don't want you to because it's part of a permanent suppression order, but a few years ago, people could easily name the club that was the subject of my master's thesis, which was published once by Channel 7. But I think now that the years have passed, it's harder and harder because there's no official documentation. You could dig around and maybe you'd find it on Big Footy or something like that. But we have to close the wall as much as we can, even if at the time we know that the public knows about it. All they know is what they think they know, which is that other people are telling them these things. And I take it, I don't know this specific case, so it might be that they know officially, but there are lots of times when people think they know, but they don't officially know because there's no actual reporting of it on the record from a specialist, from a journalist to say, right, that's the truth.
I'm not sure if any of those answers were what you were after, but...
I was more interested just in context of juries,
Yeah.
particularly with that case, because I know... Sorry, particularly in that case, because I know that order and various other orders relating to that case in the past have been put in place to try and ensure that when a jury, if he goes to trial by a jury, that the jury has as little information as possible to prejudice them if they have to reach a verdict about another crime. And I was just wondering, in this day and age, with all the information that is available, that has been available, that is still floating around on social media, because I suppose it's harder for judges to prosecute someone for breaching a suppression order on social media than it is for, say, a newspaper or a radio broadcast.
Especially if they're anonymous.
Yeah, what role a suppression order then has in that, in achieving the end of ensuring the juries are unaware.
Yeah, and obviously it's incredibly difficult. But do you have a question? Yes.
I was going to say that it all goes back to, once again, if regarding getting professional journalism, etc., it goes back to the governments. If you're not going to keep the corporations, the big corporations, from being responsible and making sure that everything is kosher, so to speak, then it's not going to happen. It's got to start somewhere. And with most of the corporate companies in the most of the politicians in the pocket of the, corporate companies, it's not going to happen. I mean, for example, you've got a horrendous thing that's happening with alcoholism. But unless you're going to make the actual clubs and pubs and everything responsible, they have got the law out there.
Right. So so you'd be supportive of Andre's approach of regulating.
Nothing is going to happen until the politicians make a stand.
Okay, that's a useful comment. So there was someone over here who was raising their hand. Thank you for that.
Really, it was one for Patrick, was just about the social media and juries question. Is there much research asking why they go to social media? In other words, are they unhappy with the court experience, with what they're hearing? Do we know anything about that?
Not yet. But there's a lot of jury research around what psychologists call reactance, which is this notion that some jurors feel as if the lawyers and the judges are all in an elaborate conspiracy to deny them truthful information that they just need to access so they can get the right result. So we'd be aware that within a criminal trial, part of the exercise is for the counsel for the defendant and for the prosecution to engage in legal argument to settle the terms of what evidence is appropriate to be adduced and what is inappropriate. So the court makes the decision, but the lawyers make submissions about what evidence is appropriate to be adduced in that trial. Now that means that there may be information that's outside the boundaries of that evidence that could infect or could pervert the considerations of the juror. And in a controlled environment, you can control access to that sort of material. But social media, because of its ubiquity and its interactivity, is creating a challenge that's of an exponentially greater difficulty of managing. And of course, the suppression order questions very amply illustrate that. So the short answer to your question is not yet. The longer answer to your question, as I just went through, is there is a lot of research around reactance that shows that even before social media, jurors were going onto the internet to do research. But even before then, they would go out to the place where a crime happened and they'd conduct their own view. I mean, that's still happening. That happened relatively recently in a Victorian matter. So, so people will disobey judicial directions. They will not take into account penalties about not researching, but social media takes things to a whole new level. Was there a question or a comment here?
Sorry, I did a commerce degree at La Trobe, but did a bit of legal, but I guess there's a flip side of it all is. Suppression is another word of censorship. So if you're my thing is, what you're really doing is curating the news and curating the content in a weird way by deleting out what you particularly don't like or what you as a country don't like.
Yeah.
So what's acceptable in Australia may be totally unacceptable in other countries and vice versa.
Yeah.
But you also get to this situation of if you let government curate or censor or suppress data, you can get to the point where there can be I guess say in China or something. So you get to the point where there can be corruption and other stuff, and you can tell the media, tell social media as they do there, we want all this hidden. If you like.
Okay, so you've got concerns around censorship, and that's something we can put to the panel members. A number of us have expressed the view that perhaps, I don't want to necessarily pigeonhole you, Andre or Mark, but you've indicated that perhaps some more regulation is necessary. Is there a significant risk here that we're entering a realm of censorship there, and that it's a good thing I'm just posing this as a hypothetical. I don't necessarily agree with this personally, I should say. But maybe it's a good thing that we have all these people expressing their opinions out there in social media, even if we don't like them, because in the marketplace of ideas approach to freedom of speech, people will choose the right thing eventually, so perhaps if we let the racists say their racist things and we accept that people have a right to be racist, as the Commonwealth Attorney General said some months ago, right to be bigoted, he said, that's a good thing because it means that in the marketplace of ideas they'll be held down in the market, and that will educate them. I'm not saying I agree with that, but I'm offering that to you to respond to.
And I'll let Andre talk about bigoted language. I'm going to kind of look at more personal information, particularly, for instance, we can take information around one's sexual life. And in fact, if one's a celebrity, that's something that a lot of news agencies would like to disclose. Let's look at Europe. In Europe, they have the European Convention on Human Rights. And there is this conflict between two articles. One article that says everyone has a right to privacy, and another article that says everyone has a right to freedom of speech. And the European Court there has to balance this. It has to do this balancing act. Now, we're not subscribed to the European Convention of Human Rights. So, we can relax, sit back. There's a whole other complex area of law, but we don't really have what they have there. I am supportive of the European Convention of Human Rights, and I'm supportive of when there are claims of breach of privacy. So, for instance, there was a topical case in 2008 around Max Mosley, who was the former head of Formula One, and who was also the son of Sir Oswald Mosley, who was a fascist. So this kind of goes into the...
Founder of the National Front.
And friends with Hitler, perhaps. And News of the World, which, as we know, is involved in hacking scandals, basically managed to find a sex worker who was going to various sexual parties at Mosley's house and asked this sex worker to put a camera in her bra and to film the activities. And then afterwards, they released all this footage on the website. And he wanted to get a suppression order. He basically wanted to get an injunction to say, take that off the website. And so what the court had to do was balance his right to privacy and freedom of speech, and in particular, the public's interest in having this information disclosed. Okay, and it is a really tough balancing act, but the courts will decide this on a case-by-case basis, and they'll look at, for instance, whether the person is a celebrity. Perhaps they have less of an entitlement to the right of privacy, and then on the other hand, whether they're not a celebrity, they have a greater right to entitlement of privacy. But surely I would suggest, we wouldn't want, for instance, our sexual life to be disclosed like that on a newspaper just because a newspaper feels that is newsworthy. So in that sense, suppression of that information, I think, is in the public's interest. But I'll hand it over to Andre.
You didn't mention Peter Slipper.
I haven't talked about Peter Slipper.
I think the first thing we need to realise is that the freedom of speech argument and where the line is not an internet debate. It's a much older discussion, and there is a fundamental difference between the United States and the rest of the world in our approach. In the United States, they have a First Amendment that says government, the actual Constitution says the government cannot abrogate freedom of the press, which read in a legal context means that they can't have those suppression orders before something happens. And it's been interpreted by the courts to say that they cannot have penalties after the fact either. And that's an interpretation. It's then been interpreted further by the court, and there is some pushback by some US lawyers on this now, and legal academics. The fact that racism in the US is regarded as freedom of speech. There's a number of categorical exceptions to freedom of speech, such as fighting words, inciting immediate violence, but racism is not one of them. Now, outside of the US, we have a different attitude to government in general. We trust in government and trust in the courts a lot more. the US have a position that they don't trust government. This is why they also have the right to bear arms, because they must be able to rise up against the government in every generation. Our view is we trust the government and we trust the courts. So the internet doesn't change that. Okay, just change the mechanism. Where we've got an issue is that we then inherit the internet, which is largely and has traditionally been largely based out of the US. And there's been this concept of the internet is different. We call it internet exceptionalism. And the experts in the field have said for quite some years now that internet exceptionalism is dead and buried. But a lot of people still advocate the internet is different. There must be absolute freedom on the internet. That argument had some weight back when the internet was much smaller and only being used by experts and computer science and academics, etc. It's now such an integrated part of everyday life that it must be treated the same way that speech is treated in the rest of our lives. And that means our approach and the US approach will differ, and we have to be able to handle that. And it comes back to where we draw the line on freedom of speech. The internet and the technology doesn't come into it at all.
That's very eloquent. As a constitutional lawyer, I should add that the Second Amendment to the US Constitution talks about a right to bear arms in a well-governed militia, which is a phrase that seems to have dropped out of the Supreme Court's construction. Was there someone over here? Because there's another person over here who had a question. Oh, Sue.
Hi, thank you. I think I want to take it back to, you talked, Dave, about making choices, making good choices. And an area that really concerns me, and Andrea, you've obviously come into it, is this young people and their exposure and their absolute acceptance of sharing. When I say young, I mean they can be 12-year-old, they can be 10-year-olds, they can be 17-year-olds, sharing every moment of their life. Every moment. I walked down, I had a cup of coffee, I went to the bathroom, my mascara didn't work, whatever it might be. And it's this instant gratification. I'm a journalist from way back. So it's that instant gratification without really, really understanding what the consequences are. And as you talked originally, the legacy that's there, you just can't get rid of it. It's there. You die, it's still there. Everything's there. So I guess the question I'm posing is, if the government hasn't got the will, where does the education start and who's responsible? So I know bullying cases at schools, a lot of parents will go screaming down to the school saying, it's your fault, to the school. Stop this Facebook, stop kids being on Facebook. Well, all they've got to do is go home. You've got parents who'll then, had an instant thing today where parents are divorced. Father has set some very strict boundaries saying, no, you're not having a phone till year 7. Mother gave the kid a phone because, we need to be able to communicate. So who's responsible and what do we do about it? Does it come through, we go right back with the AIDS and Grim Reaper, and that really, that scared the hell out of people. And even Ebola, I can see an advertising, marketing campaign going on about all that. What do we do? Where does it start? Whose role is it? Is it schools? Is it parents? How do we do it?
Okay.
Where do we start?
So who's responsible for the education and where does it start? We might get a quick burst from each of the four of you, starting with David.
All right. Well, I think it's a multifaceted. I don't think it's any one group. So I think it's parents, education, working together. I think it definitely has to be part of the curriculum. I'll try and be brief. A quick anecdote. I teach a lot of first-year students at university, and I wanted them to do a simple group exercise to sort of part break the ice, part get them writing, interviewing each other. And I said, right, pair up, you interview each other, write a few notes. I want a little profile, not a Wikipedia entry, but some kind of a story. And nothing happened. And I went, was I not clear? What's going on, guys? And they kind of shuffling, and I said, okay, so it just came to me, a moment of inspiration. I said, what you need to do is say, hello, my name's David, and shake hands, and you introduce yourself, and then they're away. They needed permission.
Yep.
And I think we take for granted, Generation X and above, take for granted the interpersonal skills that we grew up with because there was no technology. And I think it's parents, education, media. I think it's telling stories in the media. I think, we need shows. I talk about redesigning houses with my children, that there needs to be like a Qantas Club room in the centre of the house where everyone has their computers together, so that you might be doing your thing on the computer, but there's still eye contact and you're discussing what you're looking at, and the parent can easily get up and look at what's happening, so there's not I think the this kind of isolation that technology often produces, where people are in a bedroom on their own or something like that, is something. I've got the two 20-year-olds, and then we had the surprise baby. I've got the 8-year-old boy, and it's been really interesting observing the difference in raising those children, where there was VCRs and internet was dial-up, and you had to wait all night to download something.
Yeah.
To what he's on Skype playing Minecraft, with a tablet and watching TV, and it's just normal to him.
Yeah.
And I go, there's something pretty serious going on here.
Andre, who's responsible for the education, and when should it start?
If I can take the negative for a minute, what we're doing at the moment is throwing a lot of money into education in schools, and particularly in the areas of cyberbullying. To some extent, the racism gets covered there, a very tiny amount. That's not a solution on its own. Okay, I'm not saying we don't do the education in schools. I'm just saying when all the government funding goes into just that area, and there is nothing for handling the sharp, pointy end, for doing the research into the area, for doing the equivalent of the law reform work, and not just the equivalent, but actual law reform work, we've got a problem. Okay, we're just burying the issue until somebody else deals with it after the next election, and the one after that, and the one after that. There's definitely a role for parents to play. There's also a role for young people themselves to play. The Children's Commissioner went and spent the first, I don't know how many months of her role, going and talking to young people around the country. That work is important. We have youth parliaments and things like that. There needs to be that interaction. Okay? Young people need to know what the risks are, but I'd say that the position you presented of them just putting their entire life online, that was true maybe 6-7 years ago. Nowadays, when we have panels where we're talking to year 10 and 11 students, some of them are just not using social media. They don't have Facebook accounts. Okay, there's been such a hype about it that they're not getting the benefits from some of this because they've been scared off.
All right, Mark.
Yeah, I think that it really is up to the government to enshrine a right to privacy in legislation. And the reason for that is I believe it's going to have a normative impact on companies. It's basically saying to Facebook and other companies, if you want to continue doing business in Australia, you're going to have to change the way you design your privacy controls, the way you design your privacy policy. So I think it will actually have an educational effect. And the reason why I'm focusing my energy on that is, for instance, I have students who come into my intellectual property law class, and I get them to do an exercise. I get them to go into their Facebook account in front of everyone. Now, the first thing is most of them do. They have no problem, which I find surprising. So they're very willing to just do this with all their friends and show each other their Facebook accounts. And some of them are just colleagues. They might not be friends with them. But the second thing is they suddenly realize actually how the site has been designed. So, there is no education. No one's telling them, this is what happens when you like. This is what happens when you don't log out and you're searching through the internet, and Facebook are able to follow you through the internet, through the cookies, and when you like on a different site, they are gathering this data about you. So I have students who are in their 20s who are like, oh, wow, I didn't know about this. So clearly there's an issue there. I think a right to privacy will have a normative value, and the reason why I don't have much faith in, for instance, say, teaching an ethics of social media in schools is that more and more schools are requiring students to buy iPads, or they're given iPads. Even the NAFIM government recently said that every school's going to get a 3D printer. Even though there's all these issues around copyright, infringement in relation to 3D printers, there is this rush towards technology, and there's no stopping, to think about perhaps decision-making, the ethics of decision-making, and informing young people around that.
That sounds to me like you're against people getting the keys to the car because they might drink and drive.
I think they need to be informed about what they're doing, and that's so maybe I am kind of advocating that if you get the keys to the car, you have to do.
Well, don't you need to be taught how to drive it responsibly?
Yeah. I mean, but I think placing responsibility on parents. I'm not as paternalistic, and I'm not too sure how legally we would place responsibility on parents. I'm not sure if I would want that to be the case. I guess then we're left with, if you want the free iPad in schools, you're going to have to do a social media license test or something.
Wow.
I didn't get my pen license until I was in year 8, so, you know.
Okay. So what do you think, Hugh?
You weren't told what you shouldn't write and what, and that's the problem. I think, no, that's the problem that I have with saying people should sit a test before they get the iPad.
So what do you think, Hugh?
So, look, I mean, I'm going to play a slightly contrarian role.
Good.
You know,
Thank you.
That's what I'm supposed to be here for.
We've got all these people talking about regulation and ethics. So
Well,
what's your...
exactly. So I think there's two sides to it.
Yeah.
And so I think there's an element here, and we do a lot of work in cyber safety and kids, and we currently have a program running in Geelong with Victoria Police and Headspace on exactly this area. And I'm someone who's actually quite small L liberal about it. And that's perhaps because I'm a younger person. But, you know, equally, I think there is an element here that sometimes we forget of. You know, everyone has moments in their life that they regret and that are permanently etched in other people's memories. And if you think about when you were younger, there were those times and there were those scenarios that you do regret now, and that happens, and that's part of growing up. And I think sometimes one of the challenges that we do sort of face is that whole question of, are we trying to be overly protective of our kids? And I think you provide a very interesting example of your Qantas Club idea, because, you know, for one thing, I think it would be very interesting having a 15-year-old boy with a Qantas Club and, oh, what are you looking at? That could become a very interesting conversation across the dinner table. But the other side of it, I guess, is also in going...
That conversation is my point.
Well, exactly. But I think the conversation happens, and it always has. But I think the other question that I think we sometimes forget is that when you talk about people, you know, going off into their bedroom and they're connected to this computer and they're not connected to anyone else, I think we're forgetting the actual connectivity concept of social media. And so, I mean, it is called social media, not anti-social media. And there is this element of connectivity. And there's some really, really fantastic research. And I was mentioning to one of the audience members earlier, the research, particularly of Dana Boyd, is a really, really great ethnographer that does a lot of research in this area, about the role of these things in being connected, and that sense and that feeling of the person of being able to feel connected to a community. And Dana Boyd tells this story of how she was, and she'd probably be in her early 30s, I would guess, tells the story of how she grew up as a young lesbian in southern Texas, and that it was her capacity, and she talks about anonymity online, and it was her capacity to be anonymous and to join these bulletin boards and to have these conversations about sexuality and about coming out and, you know, those experiences that many of us might take for granted. It was the capacity for her to be able to do that online in an easy to access medium that was anonymous that allowed her to actually seek the benefit. And I think so really it is a very double-edged sword, as much as we might like to think it's sort of a bit of a black and white issue.
Society doesn't treat homosexuality in the right way, and so she was forced to be
There'll always be another issue. You know, there's...
But when we're talking about Facebook, we're not talking about people being anonymous. We're talking about people putting down their mobile phone number, their address, photographs at their house, in front of their lawn, with their names. I mean, I think there is so I'm all for anonymous blogging, even though a string of cases have said you can no longer be anonymous on the internet and we will reveal your identity. And in fact, News of the World will say that as well. Beyond the law, will reveal your identity. So I think there are different issues there with things like Facebook versus anonymous.
Quickly throw in that News of the World has been closed down.
Yes. Yeah, that's right.
Just can I throw it back to your Qantas Club example? What do you do with a sleepover? Do the parents sit in the room with the kids that are sleeping over the entire time, keeping an eye on everything? Or do you try and exit yourself, go upstairs, give them some space?
We take away the tablets and the phones at 10 o'clock.
No, I'm not talking about the technology.
Yeah.
I'm talking about whether the parents give the children, the young people, any space that is not heavily supervised under parental eyes, the entire time they're there. I think it's quite normal to actually give people some space.
Yeah.
And if you make the comparison, I think there's the same issue of there's a question of how much space, how much freedom, how much leeway. But if you go to either extreme, absolute extreme, it's not really going to work.
That's a perfect place to finish it. Now, I know a lot of you have got questions or comments that you'd like to make. You're very welcome to stick around for the next few minutes, but we do have to wrap up. We'll be here. We'll be able to, you can come and contact us individually and ask us your questions. Can you please join me in thanking our panel of experts tonight for their effort. I'm very pleased to give you each a gift. Thank you for your, yes, see? No, they're all the same, so you'll be getting all the same
lucky
thing.
dip?
That's great. No. Well, it's funny you should mention Lucky Dip because we do have a Lucky Door prize. Okay, and I'm going to draw it. I'm not going to look. Okay. All right. The winner of the Lucky Door prize is Angela Panuccio Gray from the Australian Competition and Consumer Commission. So if you could make yourself known, congratulations. We'll have a prize for you. Okay, thank you very much once again for joining us at this Melbourne Knowledge Week event. We're absolutely delighted to have you on board. Thank you for your patience at the start with our slightly delayed start, and thank you for staying right up onto the end, asking us such interesting questions. As you've probably anticipated, at some point I would remind you that I'm the Dean of the La Trobe Law School. We're very keen to welcome your interest in the law school if you'd like to become a lawyer after an event like that tonight. Of course, you'll want to. And I have some brochures that you can take away with you and learn about our outstanding programs for 2015. And I'm happy to answer any of your questions. So once again, thank you very much for your participation tonight. We really appreciate your attendance and your interesting questions. And again, if you could please thank the panel, but also thank my colleagues from La Trobe who put this event together. Thank you. More questions via Twitter, if you like.